think we're ready to go. So hello everyone and welcome to today's session to the Brain and Spine Foundation's Carers Rights Group for Carers Rights Week 2023. So my name is Molly and I'm a solicitor in the employment team at Irwin Mitchell. And also joining me today is my colleague Tina, and she's the head of welfare benefits in our operations team. We've also got Sophia, who's the trainee solicitor in our employment team, and she's running the slides for us today. So today we're going to discuss some of the basic employment law and benefits rights that might be useful for carers in the workplace. So we're going to cover flexible working and making a flexible working request, the types of leave that carers can take from work, the new Carers Leave Act 2023 and what we know so far on that, contractual benefits that carers might benefit from, which might be useful to you, welfare benefits that carers may be entitled to, and also where to seek legal assistance and support if needed. So the discussion today will be brief and it'll touch on the key topics that we think might be useful to you. And the session will cover generic principles. So we can answer generic questions on the content of the session at the end, but we won't be able to provide advice on specific personal queries. However, if you do need legal advice or assistance after the session, we'll provide some further information at the end of how and where you can access that. Next slide, please, Sophia. So firstly, I'm going to look at flexible working. So being able to apply for a flexible working request can be a useful right for carers who are looking to balance caring responsibilities and work commitments. Flexible working is a way of working that suits an employee's needs and that also works for the employer. The reason why it's sought is generally irrelevant, and it gives flexibility over where, when, and the hours employees work. So that could include things like compressed hours, job share, working from home, or working part-time. With some exceptions, employees with at least 26 weeks service have the right to make one statutory flexible working request a year, and that's under Section 80F of the Employment Rights Act 1996. So under the statutory procedure, a formal flexible working request has to meet certain criteria. So it needs to be made in writing and be dated. It needs to say that it's a flexible working request. It needs to say which date you'd like the change to be effective from, explain what sort of impact you think the change would make, and suggest how your employer could deal with the change, and also say if you've made a previous request, and if so, when that was. So once the employer receives the request, they would have 3 months to respond to that, and they would need to deal with the request in a reasonable manner. They can turn the request down, but the reason for that must be one of the legal grounds in the Employment Rights Act 1996. So that includes the burden of additional costs, having a detrimental impact on ability to meet customer demand, quality or performance, and an inability to recruit additional staff or reorganise the work amongst existing staff. If the request is denied, you can only make one formal request every year, but it might be possible to make an informal request of your employer. So do check the employer's flexible working policy on that. There's also been an act passed this year to update the law on flexible working. Regulations need to be enacted to bring that into force, but in future, the law governing this should be changed. And that should be changed to remove the need for the 26-week service, so make that a day one right, to allow for 2 requests each year rather than 1, to require an employer to make a decision within 2 months rather than 3, and to also require employers to consult with an employee before they reject the request. Hopefully that should happen next year, so watch this space. But at the moment, NHS workers can make requests from day 1, but others have to have 26 weeks service. Next slide, please, Sophia. Working carers should also be able to access various other types of leave that might assist them with managing caring responsibilities and looking after their own health. So do note that the majority of the rights that I'm about to discuss will be for carers who are employees or workers. But if you're unsure about your employment status and the rights you can access, we'd suggest that you seek advice on that. So firstly, holidays. So the minimum statutory holiday entitlement is 28 days in total, including bank holidays for full-time workers. Many companies do offer enhanced leave entitlement over that, so you should check your contract of employment to see how many days you've got and how you're permitted to request those. Generally, holiday has to be requested twice the amount of time you'd like to take plus a day before the leave you'd like to take. So for example, if you're wanting to take a week's leave, you need to give 2 weeks and a day's notice. but some employers will let you book sooner, and there might be something different in your employment contract. Employers can refuse leave or require it to be taken to accommodate for the business. So we do mostly see that at certain busier times of the year, for example, at Christmas. And some employers will carry over leave, will allow carryover, which can be useful if you haven't taken all your leave that year. So again, you should check that with your employer if you've got unused leave. There's also unpaid leave that you might want to take if you need time to carry out your care responsibilities, which you could try and arrange with your employer. There's no right to that as such, so it would be down to the employer's discretion. You can also take emergency leave if needed to care for a dependent. So a dependent would be defined as your child, your partner, your parent, someone who lives at your house, or someone who relies on you for care under Section 57A of the Employment Rights Act 1996. And emergency leave is for the time that's necessary to deal with an emergency, which could be things like a dependent falling ill, to make arrangements for emergency care for the dependent who's fallen ill, to deal with unforeseen issues with the care arrangement in place, or to deal with an issue that arises at school. This time off would be unpaid unless the employer offers enhanced paid emergency leave. And you would also need to tell your employer why you're absent and how long you expect to be off as soon as possible. If it's not possible for you to do that, you'll need to confirm the reason for your absence on return to work, and some employers do require that in writing. So emergency leave doesn't entitle you to take time off that might be required to provide care for lengthier periods, but it's designed for last minute and unforeseen emergencies. There's also parental leave, which is for employees who've worked for an employer for a year or more, and you would be entitled to 18 weeks of leave per child to be used before the child's 18th birthday. So you can only use 4 weeks of that leave per child per year, and leave can usually only be taken in blocks of a week unless the child is disabled, in which case shorter periods of leave can be taken. You must give your employer notice of the dates you want to take the leave at least 21 days before, and the employer can't refuse to grant it, but they can refuse to grant the days that you want and could postpone that by up to 6 months if there's a significant reason to do so. So, for example, the time you've chosen would disrupt the business. They can't postpone that leave if it's to be taken when a child is born, however. Again, that leave would be unpaid unless the employer allows otherwise. But again, some companies do have more generous parental leave schemes, so make inquiries of them to see how and if you're entitled to anything more. There's also compassionate leave, so there's no statutory right for that, but many employers will allow compassionate leave to deal with emergencies or bereavements. And again, that can be paid or unpaid depending on the employer's policies, so do check those. And then also sickness absence, so should the carer themselves become unwell, then they could take time off on sickness absence. There might be an enhanced contractual right to get sick pay, and you should speak to your employer to find out what you're entitled to and their policies for taking this leave if required. If you've got no contractual right to sick pay, you would get statutory sick pay, referred to as SSP, but only after 4 consecutive days unwell. The current SSP rate is £109.40 per week, and you can get that for up to 28 weeks. And you'd also need to obtain a fit note if your illness is for more than a week, but you can usually self-certify for less time. And you can't take sick leave because somebody else is unwell, so the carer themselves would need to be unwell to take that. Next slide, please, Sophia. So there's also another type of leave that carers will be able to take in future. So the Carers Leave Act 2023 became law in May this year, but the government will have to make some more regulations to confirm how that'll work before you'll be able to access that. And we're hoping that'll be done in 2024. So at the moment, we don't know for sure how the law will be enacted, but so far we understand that the leave will likely be only available for employees. It'll likely be for those who care for a dependent with long-term care needs, and we think that the definition of dependent will likely be similar to the definition in dependence leave. So that's your partner, child, parent, person living in your house, or person relying on you for care. It'll also be a day one right, so you won't need to accrue a certain amount of service to take that. It'll be up to 1 week's leave per year to be taken in blocks, individual days or half days. You'll likely have to give notice twice the length of the leave plus 1 day, and the leave will likely be unpaid. So do watch out for developments on that in future, as that will obviously be a key right that you might be able to access. Next slide, please, Sophia. Thank you. So I just wanted to touch on some of the other employment benefits that you might also be able to access. So I've already discussed some of the leave that you can take and some of the contractual benefits that you might be entitled to, but there might be additional things that could also help, such as private medical insurance. So you might want to check with your employer if they offer that, because sometimes private medical insurance can cover the individual and also their family members. So it might be worth looking into whether you can get any private medical help if needed. Support groups. So you might want to check if there's any support groups at work for those with caring responsibilities. So I know here at Irwin Mitchell, we do have a few different groups that offer support where employees can meet up and chat about issues that affect them. So you might see if there's any groups, or if not, why not set one up? Also, employee assistance programs. So lots of employers do provide these. They're sometimes referred to as EAPs. And these services offer support to employees with wellbeing, mental health, financial issues, and other types of query as well. So check if there's a scheme in place for you. There's also childcare voucher schemes where you can swap some of your gross salary for childcare vouchers if you signed up to that scheme one time. Or mental health first aiders. So there might be specially trained people at your company who can support you with mental health and wellbeing. So your employer may or may not offer these benefits, but it's just worth chatting to HR to see how they can support you and what you can benefit from. So I'll now pass over to Tina, who's going to cover welfare benefits.
Thanks, Molly. Right, I'm going to talk to you all about carers allowance that falls under welfare benefits. Molly, can you just nod your head if you can hear me?
Yeah, I can.
Yeah, good. Okay, just checking. Thanks. Right, so carers allowance. If you look after a family member or friend with a disability or illness, and that can include a terminal illness, you may be entitled to carers allowance. Some of you may know that carers allowance is a benefit for people who spend at least 35 hours a week caring for someone who needs regular and substantial care. It doesn't have to necessarily be physical care, or it doesn't necessarily have to be anything wrong physically with the person that you're caring for. They might have mental health needs, or it could be a mental illness that they're suffering from. So the caring doesn't actually have to be physical within that 35 hours. It could be because they find they have anxiety, or they have PTSD, or something like that where they struggle, and that could also count as the 35 hours. That can make up part of that or all of it. It does, to be eligible for the carers allowance, it does mean that you're looking after someone who wouldn't usually be able to manage everyday tasks without your help. So although there's that they don't sort of find the difference between the physical and the mental, it's got to be substantial care where someone wouldn't be able to manage everyday tasks without your help. In relation to means testing, carers allowance is not means tested, so it's not based on your income or savings, although the very important part with carers allowance is the big fact that you do have to earn less than £139 a week after tax, national insurance and expenses. So you've got to make sure that you are under that threshold. Also, if you are going to be claiming carers allowance, you've always got to check with the person that you're caring for before you apply, because it could affect some of their benefits. So if they're on other things like universal credit or PIP or something, it could affect their benefits. And normally we would do a calculation taking into that person's individual circumstances, income, whether they have got a carer or not. But if you are thinking about applying for carers allowance, it is always best to check, because it can affect either the benefits that the carer is on or the benefits that the person being looked after is on. Next slide, please, Sophia. Thank you. To qualify for carers allowance, there's certain criteria, and I've just listed them on this slide for you here. So the person that you care for must be claiming one of these benefits that I've listed there. So PIP, personal independence payment, known as PIP, you've got to be on the daily living component of that. If these bits don't make sense to you, you can always speak to us or ask us later, but they're factors within those benefits, and there's different rates that you can get those benefits at. And to qualify, that the person must be on personal independence payment at the daily living component, or disability living allowance at the middle or highest rate of the care component. They could be on attendance allowance or adult disability payment, and that's the daily living component of that one. And then there's a few others there as well. Child disability payment, the middle or highest rate of care. Constant attendance allowance at or above the normal maximum rate with an industrial injuries disablement benefit, or constant attendance allowance at the basic full day rate with a war disablement pension, or armed forces independence payment. So it's just a list there. I know it all sounds a little bit complicated, but it's a list of benefits that the person must be on, that you're caring for you to be able to qualify. And if you need further explanations of those, we could always give those at a later stage, or if you've got questions, we can answer those. Next slide, please, Sophia. There are also other conditions that you must meet if you want to claim carer's allowance, and I've just listed them there for you, so it's easy for you to see. You must be 16 or over. I've mentioned the £139, so you must earn less than £139 a week after tax, national insurance and expenses. You must spend at least 35 hours a week caring for one person. Like I said, it could be physical or a mental caring element. You mustn't be in full-time education or studying for more than 21 hours a week or more. And then the residence conditions, you must have lived in England, Scotland, Wales or Northern Ireland for 2 out of the last 3 years. And you must normally live in England, Scotland or Wales or Northern Ireland, or you live abroad as a member of the armed forces. And then there are certain immigration conditions if someone was to come to this country as an immigrant, which are very detailed, and we can find that information out for you if that did apply to you. You do not have to be related to or live with the person that you're caring for. You don't have to keep timesheets or a diary to prove that you've cared for someone for 35 hours. Carer's allowance can be taxed, and it can affect the benefits you or the person you care for receives, as I've mentioned. Also, if you are going to be claiming carer's allowance, it doesn't stop you applying for other benefits. So if you wanted to apply for universal credit or PIP or anything else, because you apply for carer's allowance doesn't prevent you from applying for other welfare benefits. Finally, if you're not eligible for carer's allowance, you may qualify for carer's credit. It's another government scheme that you can apply for if you're not eligible for carer's allowance. There is a government website link that I can share with you after this that gives more information on carer's credit if you need that. Next slide, please, Sophia. Just some more conditions regarding carer's allowance and criteria. So you can only claim carer's allowance for caring for one person. So you're not going to get any extra money if you're caring for more than one person, or if you've got grandparents that are both elderly in the same house. You'll only get the allowance for one person. Also, if you care for more than one person, you can't add the time together that you spend caring for each of them to make 35 hours. So it's got to be 35 hours that you're caring for one sole person. It can't be multiple people. Also, you can't get carer's allowance if you share the care with someone. It's got to be you, and it's got to be 35 hours. You can't get carer's allowance if you share the care of someone and the other carer is already claiming carer's allowance for that person, or the carer element of universal credit for that person. So within universal credit, if someone isn't claiming carer's allowance, there is an element within universal credit that you could claim. How much is carer's allowance? Carer's allowance is paid at the standard rate of £76.75 a week. I did check again this morning just to make sure that figure is correct. And I think that is up to date, that's £76.75 a week. Special rules for terminal illness don't apply to this benefit, and there are no extra amounts if you care for someone with a terminal illness. Can it be backdated? So if you do realise at a later stage that you could have applied for carer's allowance, your claim can be backdated for up to 3 months if you were eligible. You do not have to give a reason why you're claiming late. And then finally, as I think I've mentioned already, claiming carers allowance could have an effect on other benefits for you or the person you are caring for. So always do a check and go to an advisor, a benefits advisor, that could do a detailed benefits calculation for you, just to work out if you are going to be claiming for carers allowance, whether that person is going to be well off or less well off by you doing that. And also they could do a check on your own benefits as well, and figure out whether that carers allowance might be deducted from some of your universal credit or other benefits that you may be on. Next slide, please, Sophia. That's the end of my bit on carers allowance. Back to you, Molly.
Thanks, Tina, that's great. So I just wanted to let everyone know that if they did need legal advice or support, there's a number of options to receive that. So firstly, you could contact a legal professional for advice. So at Irwin Mitchell, we've got legal professionals that can advise you on employment law and benefits, as well as a number of other legal issues, given that we're a full service law firm. So if you do need help from us, please contact us, quoting Brain and Spine Foundation, and you'll be put through to a legal rep who will be able to explain your options for seeking advice and provide a quote for any work. If you're facing an employment issue and you're part of a trade union, you can approach your trade union to ask what legal advice and assistance they might be able to offer you. If you've got any insurance policies such as home, motor or credit card insurance, you can also contact your insurance provider to see if you benefit from any legal expenses insurance cover that would cover your legal costs for seeking advice. These policies usually only take effect after a claim's issued or for a claim to be issued, and it might be that the insurer will require a legal opinion confirming that the claim has at least 51% prospects of success for cover to be in place. But sometimes insurers do also have free legal helplines that you can call for help. So you might want to make inquiries of any insurers that you've got, just to see if they can offer you any help. And if you're unable to access any of those previous options I've just mentioned and you need free legal advice, you could also contact the Citizens Advice Bureau, who might be able to help. For employment law queries, you might also be able to seek generic advice from ACAS Legal Helpline or the ACAS website, which is an organisation that gives free legal advice to employers and employees and helps to discuss settlement of legal disputes. And there's also the Free Representation Unit, which is a charity that provides free legal advice, tribunal preparation and advocacy services to people who might not otherwise be able to afford it, but they do usually need a referral from one of their referring bodies, such as the Citizens Advice Bureau. Or you could also try to contact the Law Centres Network to see if they can offer you any free advice. I just want to explain as well that you might have heard about public funding or legal aid. That is unfortunately not available for employment claims in England and Wales. So I think that's everything from me today, unless you've got anything else to add, Tina.
No, that's great, Molly. Thank you very much. It's fantastic.